Welcome, everyone. On behalf of the trustees, the faculty, and staff, I want to welcome you to our law school. This is the fourth seminar we've now done in cooperation with the Cummings Foundation. Cummings Foundation has been helpful. They have helped to underwrite some of the costs of the program in order to blend law and business so you have a better understanding, whether you're a business person or a law student who wants to practice law and represent businesses. I think you're going to find that a lot of the information is incredibly valuable. We've got a whole group of rock star professors for you that are going to be interesting and engaging and keep the action moving for tonight. So thanks for coming, and hopefully you'll learn a lot over the course of the next hour and a half to 2 hours or so. Thank you for coming. We appreciate your interest. I'm going to turn it over to Professor Devlin, who's going to talk to you about business and the law. Thank you.
My topic is going to be entity formation. In Massachusetts, and there are many ways to run a business in Massachusetts. And I've listed 8 of them here. Sole proprietorships, partnerships, Massachusetts business trusts, limited partnerships, limited liability partnerships, limited liability companies, professional corporations, which become S-corps, and I'll explain that, or your for-profit corporation, okay? So I'm going to walk through them and give you the pros and cons. Well, the first thing you can do, as you know, is you can wake up in the morning and decide to go into business for yourself. Sure you can. It's so simple. I mean, except for some maybe pesky licensing requirements, like getting a law degree and then passing the bar. Then you get to be a lawyer. So there you are in your flannel jammies. You're eating Cheerios or Frosted Flakes or, my personal favorite, Captain Crunch. And you decide between bites to start your own business. Congratulations, you did it. You're a sole proprietor. I am so not proud of you because you're walking into a legal and financial powder keg, which if it explodes is going to hurt you badly because it's fraught with financial and legal danger. Simply put, if anything goes wrong in the business, and think a contract breach or maybe a little bit of negligence which causes somebody harm, then you are totally, 100% personally, financially and legally liable. It doesn't get much more stressful than that. And that last night's sleep is going to be the last peaceful sleep you ever have again. Okay? So you ask why? Well, the answer is what? Simple. It's because it's a sole proprietorship. That's why. And you're personally liable for all of the debts of the business. And you know what? Maybe you're even slightly successful. And maybe you hire a few employees. Wow, good for you. Well, you should be shaking in your Versace boots because if any of your employees are negligent, if anything bad happens, you are personally liable for everything. So your house, your car, your gold fillings, even my precious golf clubs are up for grabs. You can't have them. They're mine, okay? So I got to protect that because you could lose everything, maybe not the gold fillings. Now, the interesting thing about this is people out there who don't really know, they call Latin a dead language, which is interesting because you've heard of pro bono, for the good. You've heard of caveat emptor, let the buyer beware. You've heard of veni vidi vici from Caesar, I came, I saw, I conquered. You've heard of vox populi, the voice of the people. Cogito ergo sum, I think, therefore I am. Mens sano in corpore sano, a sound mind in a sound body. Amor vincit omnia, love conquers all. You want more, I know you do. Errare humanum est, to err is human. It's not a dead language. You've heard of carpe diem, seize the day. Well, I'm going to make it up right now. How about carpe vinum? Seize the wine. Yep, that's what we're going to do. It's not a dead language. But for today, we're talking about respondeat superior. Let the boss be liable, even if you did nothing wrong. Okay, so done with that. So you form a partnership. What a brilliant idea. Partnership law is statutory. It's a Chapter 108A of the Mass General Laws. And it's been the law in Massachusetts in various iterations since your grandparents were born. Really, it's that old. And it's defined under Mass General Law Chapter 108A as an association of two or more persons to carry on as co-owners a business for profit. You don't have to make a profit, you just have to try to make a profit. Think of a partnership as two or more sole proprietors who have decided to go into business together, because that's what it is. Chapter 108A, Section 15 states that all partners, quote, are jointly and severally liable for all of the debts of the partnership. Severally means individually, but if you want to pronounce that severely, then sure, you are severely liable. I'm A-okay with that. Drives home the point. So again, if there's a breach of contract, or one of your employees, or one of your partners is negligent while at work, you're personally liable. And again, just like a sole proprietor, you could lose your house, your car, your gold field, maybe even your secret family recipe for chicken piccata. You'll be so worried, oh boy, you're not going to sleep again. Well, okay, I got an idea. You become a 1% partner. And Uncle Joey will be the 99. Oh, that's brilliant. No, that's just not clever at all. Because if the partnership gets hit with a $1 million judgment against it, you are personally liable for it. All of it. $1 million, you're liable. And good luck finding Uncle Joey, because he will be long gone and far away. Okay, then have Joey run the business, and you'll be a silent partner. No, and no. You can agree not to manage the partnership operations, but it won't change your liability risk one iota. As a matter of fact, it probably is going to increase it. Why? Because I've met your Uncle Joey, and the only thing he's capable of running is a red light. Okay? So don't do business as a sole proprietor. Don't do business as a partner in a partnership. There are less stressful and financially more attractive ways to conduct business in this wonderful Commonwealth. By the way, you need to be careful with whom you conduct business and how you structure your business relationships with other businesses, because there's something known as an unintentional partnership, and that's treated as a partnership. So be careful out there. That leads to my next topic, which is the Massachusetts Business Trust. They've been around for so long. They came into being because attorneys are pretty smart, and attorneys are constantly thinking of ways around the problems. Loopholes, I think we call them. Well, one big reason they came into use is because way back when, corporations had to go to the state legislature to get approval to do just about anything, including owning land. That is time-consuming. It's not even a guarantee. So why not just create a trust? And that's what everybody did. Moguls like John D. Rockefeller and Andrew Carnegie, well, they used them to create vast empires, vast business empires. And those vast business empires were monopolies. And when the feds went after them by enacting anti-monopoly statutes, they called them antitrust laws. That's a misnomer. They're anti-monopoly laws, but that's where it comes from. You see this nowadays, not very often. You see it with real estate investment trusts, REITs, and you see it with mutual funds. And maybe we'll talk about them someday. But today, just wanted to let you know they exist. Okay, so now we're going to get statutory. How about a limited partnership? This is number 4, sole proprietorship partnership, Massachusetts Business Trust, a limited partnership. Chapter 109, Mass General Laws. And Chapter 109, it became the law in Massachusetts about 50 years ago. And the reason for it is, well, let me explain. First, you're going to have to start to now, when we're talking about the remaining business entities, you're going to have to file paperwork with the Secretary of State, Commonwealth of Massachusetts. And if you don't, then you're just a partnership and you won't sleep again. So you got to file. It's an exceedingly awkward business structure. You need at least one general partner. And then you need limited partners. That's why they call it a limited partnership. So you can do it. Now, the general partner is going to be personally liable. The good news is that the limited partners have limited liability. They're limited to the amount of their investment. So if you agree to put in $100,000 into this limited partnership, you could lose $100,000, but you won't lose your house or your car or your precious golf clubs, because your liability is limited to the amount of your investment. The problem with it, though, is the downside. And the downside is, as a limited partner, you are not allowed to manage the business. You're not. Chapter 109 is pretty clear about it. It says that, quote, a limited partner is not liable for the obligations of a limited partnership unless they're also a general partner, and a general partner has unlimited liability. So you can be both. Or they participate in the control of the business. You do either one of those, and you're 100% liable. You say, where did this come from? Well, the reason it came about was about 50 years ago, 60 years ago maybe, is because, and the reason why you've never heard of them, is because back then, what wealthy people wanted was, by the way, we didn't have LLPs and LLCs and S Corps yet. So being a limited partnership was an investment vehicle. And you get your write-offs, you get your tax deductions, and only one level of taxation, which I'll get to in a bit. And you're not personally liable. It's just an investment, like buying stock in NVIDIA or IBM, or Tesla for that matter. So we move on to limited liability partnerships. And Massachusetts said, oh, wow, we're going to have another statute? Massachusetts said, no, it's a partnership. So we're just going to glom on a couple of sections onto Mass General Law, Chapter 108A, which is the partnership statute. And what they did was, remember Section 15, which says that you're jointly and severely liable. Well, we're going to go back to Section 15. And that states that a partner in an LLP, a limited liability partnership, shall not be personally liable, directly or indirectly, for the debts and obligations of the limited liability partnership. And that's the best of both worlds. You get to have your cake, tax breaks, limited liability, and you get to eat it too, manage the business. Awesome. So LLPs are almost exclusively used by doctors, lawyers, accountants, and other licensed professionals who supply services. And typically, under state licensing requirements, these types of professions are not allowed to be in a regular partnership with unlicensed professionals. It's not allowed. So be an LLP. Not bad. You only lose your investment in the LLP. If the LLP goes bankrupt because of whatever you put into that LLP, you'll lose it and nothing more. Unless, of course, you were personally liable and caused some problems, because you're never going to escape your own liability. I'm sorry, your own negligence. A sister, a brother, a sibling of an LLP is an LLC. An LLC is a limited liability company. It's a Chapter 156C. You don't need anybody else because it's a limited liability company, not a partnership. So you can do it yourself. And you can have as many owners, members as you want. Like LLPs, you've got to file with the Secretary of State, both to start it and then on an annual basis. Members can manage the LLC. They can hire someone to manage the LLC, and this person is called, you wait for it, the manager. Imagine that. Here's the important stuff. Chapter 156C, Section 22 states, oh boy, a lawyer wrote this. The debts, obligations, and liabilities of a limited liability company whether arising in tort, contract, or otherwise, shall be solely the debts, obligations, and liabilities of the limited liability company. And no member or manager of a limited liability company shall be personally liable solely by reason of being a member or acting as a manager of the limited liability company. That's pretty clear. It's wordy, but it's clear. Good. Now, there are minor differences for purposes of this discussion. There are minor differences in the structure and terminology of limited liability companies and limited liability partnerships. The big picture is clear. Imagine being the owner of a business that you can run how you see fit, be able to claim business losses against your other massive sources of income, have only one level of taxation because they're known for tax purposes as flow-through entities or pass-through entities, and be shielded from so much possible legal and financial calamity. Wow. Here's your cake. You ready for it? You can eat it. You can share it with your friends. You can feed it to the dog. Or, my advice, you can throw it at your brother-in-law, because that's a waspy bug cake. That's what that is. You be careful out there, okay? So then we get to professional corporations, PCs. Now, they're codified at 156A of the Mass General Laws, and they came around about 50 years ago, I think 60, 70 years ago. 156A is clear. It says the personal liability of a shareholder of a professional corporation shall be no greater in any respect than that of a shareholder of a corporation organized under Chapter 156D, which is the corporate law statute in Massachusetts. So it's no more liability than if you were a shareholder of IBM. You could lose your investment. IBM could go bankrupt, but that's it. You're not going to be personally liable. Now, the statute was enacted to allow certain professions like doctors and lawyers to incorporate and take advantage of pension and profit sharing plans, which were allowed to corporations way back then. So you don't really need them now, but you also didn't want that double level of taxation. So now we're going to introduce some taxes to you. There's something known as an S Corp, or a subchapter S corporation. If you are a PC, a professional corporation, or even 156D regular corporation, you can file a form with the IRS and elect S corporation status, which means you're going to be taxed like an LLP or an LLC or it's going to flow through. There's not going to be any double level of taxation. That's what an S corp is, and many PCs take advantage to avoid the double taxation imposed on regular corporations. And that double taxation is simple. Corporations pay their own taxes. If there's anything left, they might issue to you, the stockholders, a dividend, and you're going to pay taxes on that. So you've got a double level of taxation. Who wants that? One way to get rid of it is become an S corp. But again, while there still might be reasons, it's just so much, I don't know. People know what limited liability partnerships are. They know what limited liability companies are. PCs, not so much. I'm not suggesting you should avoid them. I'm just saying they're not in the vernacular. And as I mentioned, my last topic is corporations. They have been around forever. The latest Massachusetts statutory iteration, it used to be 156B, now it's 156D of the Mass General Laws. And their taxation is governed under subchapter C of the Internal Revenue Code, which is why sometimes they're called C Corps to just differentiate them from S Corps, or they're just called corporations. And they're everything you can think of. They are FedEx, they're, I was driving here today and I passed a truck. Okay, fine, the truck passed me. And it was Fred and Sons Painting Company, Inc. That's a C corporation, I know that. There it is, it's everything out there that you can think of. Corporations, by the way, were the original best of both worlds, because way back when you didn't have this. But now when corporations came into being, they separated the ownership of the business with the management. So they allowed the owners, the stockholders, the investors, the ability to invest in a business and not be personally liable, because it's the corporation that is liable. It's the corporation that is the principal. So these are wealthy people, and they don't want to be subjected to unlimited liability. And that's what the corporation did. It was absolutely groundbreaking when it happened 17,000 years ago. It's rather ho-hum today. It really is. Many attorneys will tell you that since corporations have been around for so long, there's such a body of case law, hundreds of years of case law. So if you're going to be a C Corp, your attorney knows what to tell you to do and what not to do, because there's so much case law out there. Attorneys are striving for certainty, and with a little bit of research, they can be pretty darn certain, telling you, the business owner, what to do and be careful what not to do. The recent upstarts, we'll call them the younger siblings, LLPs and LLCs, they don't have that much case law behind them. So there's a little bit more uncertainty about them. So I'm going to say that corporations are still the go-to, but LLPs and LLCs, they're catching up, they're maturing. So now, trying to explain this again, one problem with C Corps is they pay their own taxes. And if there's anything left over, then they'll issue you, the owners, a dividend, and you pay tax on that. That's a double layer of taxation. This double layer of taxation, this double taxation, doesn't occur with LLPs, LLCs, or S Corps. It doesn't. So when you're advising clients to incorporate their businesses, that's great legal advice, because it's still the go-to method for limiting personal liability. LLPs and LLCs, the operational flexibility which they give you, they're catching up quite quickly, as a matter of fact. So we're down to 4 possibilities, folks. You can organize your business as a limited liability partnership. You should organize your business as a limited liability company. You could do it as a professional corp, a PC, and then elect S Corp status. Or you could have a regular corporation, and if you want, elect S Corp status for that too. Any one of those I'm comfortable with, and you will sleep like a baby. You got any questions? Well, that's my email address. Thank you very much, folks.